A New York court has delivered a judgment that strikes at the very heart of the Trump empire. And this isn't just another lawsuit in a long line of legal battles. It's a ruling that has been called a corporate death penalty, a legal maneuver that threatens to dissolve the very companies behind iconic, globally recognized assets like Trump Tower. The decision came with a staggering financial penalty closing in on $500 million, coupled with unprecedented bans on Donald Trump and his sons from running their own businesses in their home state. This is more than a legal defeat or a financial setback. It's an existential crisis for a name that was once synonymous with wealth, power, and the art of the deals. So, how did it come to this? How can a single judge, in a civil trial, effectively order the dismantling of a family dynasty and temporarily bar its patriarch from the world of finance in his own state? And what does it mean when the government of the state where you built your empire decides you can no longer be trusted to do business within its borders? This story is about more than just money or politics. It's about the fundamental rules of business, the immense power of the law, and the potential unraveling of one of modern history's most famous and polarizing brands. We're breaking down the historic ruling against the Trump Organization, the decade of alleged deception that led to it, and the long legal war that will decide if the name Trump can be erased from the New York business world for good. The pivotal moment landed on February 16, 2024. After a dramatic 11-week trial, Justice Arthur Engoron delivered a comprehensive 92-page ruling that was as scathing in its language as it was severe in its penalties. The verdict found Donald Trump, his sons Don Jr. and Eric, and their family business, the Trump Organization, liable for a years-long scheme of massive fraud. The headline-grabbing number was, without a doubt, the financial penalty. Engoron ordered the defendants to pay a colossal $355 million in disgorgement, a legal term for forcing a party to pay back ill-gotten gains. But that was just the base figure. With pre-judgment interest tacked on, the total penalty skyrocketed to over $450 million. This wasn't a slap on the wrist. It was a financial sledgehammer designed to sting. And the interest keeps accruing, adding more than $114,000 to the total every single day. Yet the money, as monumental as it was, arguably wasn't the most devastating part of the ruling. Engoron also imposed crippling non-financial sanctions. Donald Trump was banned from serving as an officer or director of any New York corporation for 3 years. His sons, Don Jr. and Eric, received similar bans for 2 years. Furthermore, they were all barred from applying for loans from any bank registered in the state of New York, a direct strike at the lifeline of a real estate empire famously built on financial leverage. To enforce this, the judge expanded the power of an independent monitor, retired Judge Barbara Jones, who was already in place to watch over the company's finances. He also ordered a new independent director of compliance to be embedded within the company. In essence, the court put the Trump Organization under a form of corporate probation, with internal and external watchdogs installed to prevent the kind of misconduct the court had just condemned. This final verdict was the culmination of a process that began months earlier, on September 26, 2023, with a powerful pre-trial ruling. It was then that Judge Engoron dropped the initial bombshell. He found Trump and his company liable for fraud before the main trial even started, based on what he deemed overwhelming and undisputed evidence. At that time, he ordered the cancellation of the business certificates for the companies controlling many of his key New York properties. This was the so-called corporate death penalty, the state revoking their license to exist. That order sent an immediate shockwave through the legal and business communities. It meant a court-appointed receiver could be put in charge of dissolving these companies and potentially selling off the assets. However, on October 6, 2023, an appellate judge paused that specific drastic order. So while the death penalty had been pronounced, the execution was put on hold pending further arguments. Still, the final February 2024 ruling left no doubt about the judge's stern assessment. Engoron wrote that the defendants' complete lack of contrition and remorse borders on pathological. He described their defense as belonging to a fantasy world and concluded their persistent refusal to admit error made the severe penalties a necessity to protect the marketplace. For decades, Donald Trump built a global brand as a master dealmaker. Now, a New York judge had officially branded his business as being built on the art of the steal. This legal earthquake didn't happen overnight. You can trace the first tremors back to February 2019, when Michael Cohen, Trump's former personal attorney and fixer, testified before the U.S. Congress. He alleged that Trump routinely and illegally inflated his asset values on financial statements to secure better loans from banks. That testimony was the spark that ignited the flame. New York Attorney General Letitia James launched a sprawling investigation that would span years, involving millions of pages of documents and dozens of witness interviews. The lawsuit she eventually filed in September 2022 wasn't about Trump being secretly broke. It was precisely the opposite. The case argued he and his organization were so obsessed with the appearance of immense wealth that they systematically and repeatedly lied about his net worth for years to gain financial advantages. The core of the case was deception, not insolvency. And the examples of fraud the court found were, frankly, audacious in their simplicity and scale. Take the most famous one, Trump's triplex apartment in Trump Tower. For years, his official statements of financial condition claimed the apartment was nearly 30,000 square feet. But public city records clearly show it's actually 10,996 square feet. That wasn't a minor clerical error. It was a nearly threefold inflation that artificially boosted the apartment's value by as much as $200 million in some years. When confronted with this discrepancy, Trump's former CFO, Alan Weisselberg, dismissed it as a simple mistake. The judge saw it as clear-cut material fraud. Then there's Mar-a-Lago, his exclusive club in Palm Beach, Florida. Trump's financial statements valued the property as high as $739 million. This valuation was based on the hypothetical idea that it could be sold and developed as a private residence. In reality, Trump had signed away his legal rights to develop the property for any purpose other than its current use as a social club. According to an appraiser's analysis, these legal restrictions meant its real value was closer to a range of $18 to $28 million. The valuation was inflated by over 2,000%. The court found that claiming a value based on a use that was legally forbidden wasn't an aggressive business tactic, but blatant fraud. This pattern was repeated across the property portfolio, from the Seven Springs estate in Westchester County to the Trump Park Avenue property. These weren't just optimistic projections. They were, as the court found, knowing lies compiled into official statements of financial condition. Those statements were then presented to financial institutions like Deutsche Bank to get better interest rates on massive loans. The defense argued that these were sophisticated banks that did their own due diligence and were capable of protecting themselves. They also pointed out that Trump's financial statements even included a worthless clause disclaimer. But that argument ran headlong into the specific and powerful New York law used to prosecute the case. Executive Law, Paragraph 63-12. To win under this statute, the Attorney General didn't have to prove that the banks were tricked, that they lost money, or even that the defendants intended to commit fraud. In fact, Deutsche Bank made plenty of money on its deals with Trump. Under Section 63-12, that doesn't matter. The law targets persistent and repeated fraud in business dealings. Crucially, prosecutors just had to prove that the statements were false and were used in the course of business. The fact that Trump's apartment was not 30,000 square feet was a fact, not an opinion. Listing it that way on statements used to obtain loans was, in the eyes of this specific law, enough to prove the case. The victim in this context wasn't just the bank, but the integrity of the entire market. This unique legal weapon was so effective that Judge Engoron ruled on the core fraud claim before the trial even started, declaring the evidence overwhelming and undisputed. The dramatic trial that followed wasn't to decide if they committed fraud. The judge had already decided that they had, but to determine the extent of the punishment. The fallout from the verdict created three cascading crises for the Trump organization: a financial catastrophe, an existential threat to its corporate structure, and a fundamental attack on the power of the Trump name itself. First, the money. A judgment of nearly $500 million presented an immediate and severe cash catastrophe. To even appeal the verdict, Trump was required to post a bond for the full amount to guarantee to the state he couldn't just move or hide his assets. Suddenly, the man who built a global brand on the image of immense wealth had his lawyers telling a court that securing a bond of that magnitude was a practical impossibility after being rejected by dozens of financial firms. It was a stunning admission. With the clock ticking towards a deadline, Attorney General Letitia James made it clear she was ready to begin the process of seizing assets, potentially including his buildings. Then, at the 11th hour, an appeals court offered a critical lifeline. On March 25, 2024, it paused the collection of the massive judgment, provided Trump posted a much smaller, more manageable $175 million bond, which he subsequently secured. The immediate crisis of asset seizure was averted, but the full $500 million judgment wasn't erased. It still loomed, gathering interest daily, pending the outcome of the appeal. This leads to the second crisis, the corporate death penalty. When Judge Engoron first ordered the cancellation of Trump's business certificates in his pretrial ruling, he was effectively saying, "You are no longer allowed to do business here." This was the most dramatic and unprecedented part of the ruling, but an appeals court quickly put it on hold. The lights are still on at Trump Tower. But the threat isn't gone. It has merely changed form. The final verdict replaced the idea of immediate dissolution with a kind of death by 1,000 cuts. The court-appointed monitor and the new compliance director mean the Trump organization is no longer its own master. It is now operating in a corporate straitjacket, its every significant financial move scrutinized. The family is barred from leadership roles in New York and can't even apply for a loan in their home state. It's a slow-motion implosion of control, specifically designed to stop the company from repeating the kind of fraud the court found to be so routine. Finally, and perhaps most importantly in the long run, is the attack on the Trump name itself. The brand's value isn't just in steel and glass. It's in the perception of elite success and business genius the name is meant to convey. This verdict systematically demolishes that image. It replaces the myth of a business mastermind with a court-certified record of persistent and pathological fraud. How do you market a brand based on success when a judge has banned you from running a business in your home state? The name, once its greatest asset, is now inextricably linked to a massive judgment for fraud, making the empire potentially too toxic for the rest of the legitimate business world to touch. The February 2024 verdict was not the end of the story. It was just the beginning of a new, protracted legal war. Trump's team immediately filed an appeal, and their arguments were multifaceted. First, they claimed the nearly $500 million penalty was an unconstitutionally excessive fine, particularly since the banks involved were sophisticated institutions that lost no money on the deals. Second, they argued the powerful fraud law itself, Executive Law Paragraph 6312, was misapplied, contending it was originally intended for consumer scams, not complex, high-finance real estate deals between corporate giants. Then, in a dramatic, and for the purposes of this narrative, hypothetical twist, in August 2025, a deeply fractured appellate panel handed down a shocking ruling. In this scenario, the judges all agreed with the lower court's finding that Trump and his company were liable for fraud. However, they overturned the massive monetary judgment, calling it a punitive and excessive fine that violates the Eighth Amendment of the Constitution. It was a huge financial victory for Trump. However, the hypothetical panel left the other sanctions in place, including the independent monitor and the bans on Trump and his sons from running New York companies. Though enforcement of those bans had already been paused back in March 2024, pending the appeal's outcome. Naturally, both sides vowed to keep fighting this hypothetical decision. AG Letitia James immediately announced she will appeal to the state's highest court, the Court of Appeals, to have the massive financial penalty reinstated, arguing that disgorgement of ill-gotten gains is not a fine and is necessary to deter future fraud. Meanwhile, Trump's team is appealing to that same high court to have the remaining sanctions, like the business bans and monitorship, thrown out as well. This means the entire case is now heading for a final decisive showdown. This appellate process will stretch well into the future, creating a prolonged period of legal limbo. While the financial penalty has been wiped out for now in this scenario, the underlying verdict of liability for massive years-long fraud still stands. If the Court of Appeals ultimately sides with the Attorney General, the $500 million financial crisis will be back with a vengeance, and the prospect of forced asset sales could become a reality once more. If it sides completely with Trump, he could escape the penalties for good, leaving the state with a fraud finding, but no teeth to enforce it. The fate of the Trump Organization's future in New York now rests entirely in the hands of the state's top judges. So what we have is a landmark judgment finding massive and persistent fraud, followed by a shocking, albeit hypothetical, appellate ruling that threw out the historic fine while leaving the damning verdict itself intact. The Trump Organization remains under unprecedented court supervision, and its leaders have been branded by a New York court as untrustworthy, even as they scored a major victory saving their bank accounts, at least for the time being. The legal system, moving at its own deliberate, grinding pace, has shattered the core of the Trump brand, the image of untouchable financial success. The verdict stands, but the ultimate question of what penalties, if any, will stick is now headed to New York's highest court for a final answer. The final chapter of this saga is far from written, and the battle for the future of the Trump name and the empire it represents is only just beginning. If you want to keep up with developing stories like this one, which cut through the worlds of law, business, and politics, make sure to subscribe and hit that notification bell so you don't miss our next breakdown.